Yesterday, a court ruling in the Nye County Courthouse, Judge Robert Lane rendered his decision regarding redoing the primary election for the Nye County Commissioner District 4 seat, in which candidate Donna Cox and her attorney Nancy Lord filed a complaint against the Nye County Clerk's office and Sandra Molino in regards to the tally of votes. Mrs. Cox came in with a total of 249 votes. Incumbent Commissioner Butch Boraski and candidate Carl Moore tied at 381 votes each. The suit was filed based on the belief that precincts were drawn incorrectly in the area of Calvada and Pahrump Valley Boulevard, resulting in an incorrect tally, in which Ms. Cox did a door-to-door survey. Judge Lane agreed to hear testimony yesterday and gave his decision.
What do you want me to do today, and so forth? And she said, I would like these 8 things. And the state stipulated to give her 7 of those things. The only thing they didn't stipulate to was the District 4 redoing the primary. So you just heard the hearing for the last hour that we had, where the state basically said, in order to challenge where somebody lives and where they're improperly voting, you have to do it pursuant to subsection 547 and 310, or I don't remember, 290. Anyway, you have to follow these grounds to challenge it. In order to meet the burden of showing that there were illegal votes cast pursuant to 293.410 subsection 2C, in order to get a new election, you would have to show that there were illegal votes cast for the candidates sufficient to have the election contested. Ms. Lord could not meet that burden today, as you've all heard for the last couple hours. And so I've denied the challenge regarding District 4. We went into chambers to make sure that everybody understood what was being done today. And we re-clarified again for Ms. Lord that the state was stipulating to giving her all those documents that she requested. They were not stipulating to continue this contest, which hearing was set for today. If she is to contest these matters, she has to present the evidence today pursuant to the statutes. She has not done so and stipulated in chambers and said, I merely want these items so that I can review them to see if the election was done properly or not. A month from now, after she reviews those items, she may, if she wants to, has the prerogative to resubmit a new petition to contest this election. The state will probably oppose it at that time as being beyond the time limits of when you can contest an election. However, based on the information that I've received today, the court would find that there has not been probable cause evidence presented to the court to grant the petition for the contest. Anything else I've missed or needs to be said?
Well, but we are still getting the material.
A lot of judges who can read pleadings and walk out in the first 10 minutes and say, I don't need to hear nothing, I've made the decision and this is it. I could do that too, and a lot of people like that because it's a lot faster. But my philosophy is, with divorces and civil actions and these kind of actions, is I like to give everybody the opportunity to say their piece. They may not agree with my decision, but at least they'll walk out of the courtroom saying, at least I got to say my piece, at least it was fair. And so I have a tendency to let people talk more than some people might. But I hope I gave everyone that opportunity today. You got to say your piece, and I hope everyone understands my decision and judgment. We'll ask Ms. Jones and Ms. Lotek to prepare the order on this matter.
Yes, Your Honor.
Court's adjourned. Thank you.
This is Deanna O'Donnell for News 41.